Welcome to BusinessTraining.com. The video module today will be focusing on the National Labor Relations Act. This is our agenda for the video topic today. Please take a moment to review the outline. The National Labor Relations Act, also known as the Wagner Act, was passed in 1935 and established the federal agency, National Labor Relations Board. The National Labor Relations Board, or NLRB, has the power to investigate and decide on charges of unfair labor practices and conduct elections in which workers would have the opportunity to decide whether they want to be represented by a union. The National Labor Relations Act limits the means by which employers may react to workers in the private sector who create labor unions, engage in collective bargaining, and take part in strikes or other forms of concerted activity in support of their demands. The NLRA applies only to workers in the private sector and the United States Postal Service. It does not apply to workers who are covered under the Railway Labor Act, agricultural employees, domestic employees, supervisors in private sectors, federal, state, or local government workers except for the U.S. Postal Service, independent contractors, and close relatives of individual employees. Under the NLRA, workers have the right to organize unions and other concerted activities with the purpose of collective bargaining or other mutual protection. Employers may not retaliate or discipline employees for exercising their rights to organize or other concerted activities. Concerted activities is a right to act in concert with one or more employees in furtherance of a common concern regarding any term or condition of employment. For example, an employee may speak individually to an employer on behalf of himself and one or more coworkers about improving workplace conditions, or employees may walk out, petition, or file a group complaint. As workers may organize and join unions, most labor unions fall under two larger umbrella organizations. The first is the American Federation of Labor, Congress of Industrial Organizations, or AFL-CIO. And the second is the Change to Win Federation, which split from the AFL-CIO. Union membership has been declining for decades, but these two organizations still oversee most of the labor unions in the United States. Unions negotiate the conditions of employment with employers and write in terms in a legally binding contract. Workers are protected to strike and picket under the NLRA as long as they are lawful strikes or pickets. Protected workers are free to choose to join a union or engage in union activities, and any are able to organize coworkers to decertify a union as their representation. Members of unions hold Weingarten rights, which state that employers question a union member on a matter that may lead to discipline or other changes in working conditions. Union members can request representation by a union representative and decline to answer questions until the representative arrives. If the employer denies the representation, then they either must end the interview or ask if the employee wants to continue the interview without the representative, and end the interview if they choose not to. If an employer disregards this and continues to ask questions, the employee is not required to answer. Unions require members to pay dues, and the amount of dues that are collected from union employees are subject to federal and state laws and court rulings. The National Labor Relations Act allows employers and unions to enter into several union security agreements. Depending on the type, employers and unions could require all employees in a bargaining unit to become union members and begin paying union dues and fees within 30 days of employment. This type of union security agreement is available in a non-right-to-work statute state. Even under a security agreement, employees who object to full union membership may continue as core members of the union and pay only the share of dues that are used directly for representation, such as collective bargaining and contract administration, and not pay the share used for other means, such as political lobbying. These members are known as objectors and still protected by the union contract. This right is known as the Beck right, and unions are obligated to tell all covered employees about this option and allow them to exercise this right. Over 20 states now have the right-to-work statutes that prohibit labor unions and employers making agreements that membership or payment union dues or fees is a condition of employment before or after hiring. Supporters of right-to-work statutes argue that the prohibited practice creates a forced unionism where supporters of non-right-to-work statutes argue that non-union employees benefit or free ride from the collective bargaining of the union without paying dues, which weaken unions in laws, wages, and worker safety and health. To start a union with an employer, an organizer who works for a union may contact a number of employees, or the employees may choose to contact the union on their own accord. The union will gather employee signatures and garner support that the employees want a union to represent them. The union needs at least 30% of employees in a proposed bargaining unit before asking the National Labor Relations Board to hold an election. The National Labor Relations Act provides two processes by which a labor union can be certified as a bargaining representative for a company's employees. The first process, known as a card check process, is a voluntary recognition method. A labor union provides the employer with authorization cards signed by a simple majority of 50% plus one of its employees. The employer may take these cards and voluntarily recognize them as proof of the employee's desire for union representation. If they choose to do so, the NLRB will certify the union. This is the easiest and most effective way for union formation. The second method is a secret ballot election, which is currently the standard method for union formation. If the employer denies the card check method, the labor union will continue to gather signatures of employees interested in hosting a secret ballot election. Once the election petition is filed, the NLRB takes between 45 to 90 days to conduct the secret ballot election and sharply limits what the company management can say or do, otherwise they may be subject to unfair labor practices. The union must win the election by a majority vote of workers to represent all employees in a bargaining unit. The losing side may contest the election with the NLRB. Due to the ease of the card check system and the possibility of corruption and hindrance under the lengthier secret ballot election method, unions are pressuring Congress to pass legislation to do away with secret ballot elections in favor of the card check method through the Employee Free Choice Act. For minor violations during the limitation period on employers of a secret ballot election, the NLRB may simply order employers to stop. In the case of a serious violation and the labor union losing, the NLRB could order a new election. And for extremely severe violations, the NLRB can rule that the labor union wins by default. The NLRB determines severity of violations. Employers can generally limit the union's campaign activities on company property and using their resources in the same way that they limit other solicitations. However, if the employer has been lax in enforcing the rule, they cannot suddenly start enforcing it when a union starts campaigning. There are numerous unfair labor practices established by the NLRB that apply to both employers and labor unions. Employers, for example, cannot threaten employees with termination or loss of benefits if they join or support a union or engage in a protected concerted activity. Employers cannot promise benefits to employees to discourage union support. They may not transfer, lay off, terminate, or assign employees with difficult work tasks or punish employees in retaliation for filing an unfair labor practice charge or participating in an investigation conducted by the NLRB. Employers may not interfere with, restrain, or coerce employees in exercising their rights of freedom of association, mutual protection, or to form, join, or assist labor organizations to bargain collectively for wages and working conditions, or other concerted activities. Nor may employers refuse to bargain collectively with the representative of the employees. Labor unions are also subject to unfair labor practices. They may not threaten employees that they will lose their jobs unless they support the union, and they may not seek the suspension, discharge, or punishment of an employee for not being a member of the union. Unions may not engage in picket line misconduct, to include threatening, assaulting, or barring non-strikers from the employer's premise, nor may they strike over issues unrelated to employment terms and conditions. After employees choose a union as a bargaining representative, the employers and the union are required to meet at reasonable times to bargain in good faith over wages, hours, vacation time, insurance, safety practices, and other mandatory subjects. Neither party may refuse to bargain collectively with the other, but they are not compelled to reach an agreement or make concessions. If after sufficient good faith efforts no agreement can be reached, the employer may declare an impasse and then implement the last offer presented to the union. The union may disagree that a true impasse has been reached and file a charge of unfair labor practice for failure to bargain in good faith with the NLRB. The NLRB will then determine whether a true impasse was reached based on the history of negotiations and an understanding of both parties, and the employer may be asked to return to the bargaining table. Once the contract expires, however, the obligations do not end. Both parties must bargain in good faith for a successor contract or termination of agreement while the terms of the expired contract continue. The party that wishes to end the contract must notify the other party in writing 60 days before expiration date or proposed termination date and meet and confer with the other party. If you would like more information on the National Labor Relations Act and unions, please go to the National Labor and Relations Board website at the following link. Thank you once again for your time and attention, and this is BusinessTraining.com, where you can earn a master's level qualification to make more money.